If you've ever lived at a place with a homeowners association, an HOA, you get it. They can be great, sure, for keeping the neighborhood looking sharp, but man, do they come with a thick rule book. And sometimes those rules can spark some pretty serious disagreements. So we're going to dig into this really fascinating case that shows just how powerful the fine print can be. And that really begs the question, right? Can a single word, maybe just buried deep in some boring legal document, actually be the thing that wins you a legal fight against a big organization? Well, as you're about to find out, the answer is a big, fat yes. All right, so let's meet the players. In one corner, we've got our homeowner, Michael J. Stoltenberg, and in the other, we have the Rancho Del Oro Homeowners Association. You've got a classic David versus Goliath setup here, a real showdown over rules, contracts, and what words really mean. So the whole thing kicked off with a letter in the mail. The HOA let everyone know that dues were going up by 10% for 2019 to $154 a month. Now here's the kicker. 10% was the absolute maximum they could raise it without getting a vote from all the homeowners. They pushed it right to the legal limit. But Mr. Stoltenberg read the notice and something just didn't feel right. And it wasn't the price hike itself. See, his whole challenge wasn't going to be about the money. It was about the process. He zeroed in on one very specific and, as it turns out, very important rule. Okay, here it is, the exact language pulled right from the HOA's own rulebook, Section 4.3. It says the budget has to be delivered to every homeowner at least 15 days before the meeting. Now, I want you to burn that word into your brain. Delivered. That one word, that's the whole shebang. And when you look at the timeline, you can see the problem clear as day. The HOA stuck the budget in the mail on January 2nd. The meeting was on January 17th. Now that's exactly 15 days. But the rule doesn't say mailed 15 days prior, it says delivered. And there's just no way a letter gets from a mailbox into your hands on the very same day. The math just doesn't add up. So what did Mr. Stoltenberg do? He took this to an administrative hearing. And get this is pretty brilliant, actually. He had a whole list of things he could have complained about, but he chose to put all his eggs in one basket. His entire case was focused on this one single violation of that 15-day delivery rule, a laser-focused strategy. Now, in a case like this, you don't need to prove something beyond a reasonable doubt like you see on TV crime shows. The bar here was much lower. It's called preponderance of the evidence. All that really means is that his argument just had to be a tiny bit more convincing than the HOA's. Think of it like a scale that just needs to tip, even just a little, in his favor. So, this is it. This is what the entire argument boiled down to. On the left, you've got Mr. Stoltenberg's case. Delivered means received. It has to be physically in the homeowner's hands. On the right, you have the HOA's case, which was basically, delivered just means the day we dropped it in the mail. The judge had to decide which one was right. So after all the back and forth, the arguments were made, and the judge was ready to make the call. The fate of this entire dispute, all resting on the meaning of that single word, was about to be decided. And boom, the finding was crystal clear. The judge sided with Mr. Stoltenberg. The evidence showed that the budget was absolutely not delivered 15 days before the meeting, like the rules required. The judge concluded that the HOA had, in fact, violated its own governing documents. A huge win on the central argument. But here's where it gets really interesting, because the final order wasn't quite a simple win. It had 3 parts. First, Mr. Stoltenberg was officially named the prevailing party. He won the legal point. Second, and this is a big one, his request to actually cancel the dues increase, denied. But third, the HOA was ordered to pay him back his $500 filing fee. So this raises a super interesting question, doesn't it? He won the case, he was proven right, but the dues increase, the very thing that kicked this whole thing off, stayed in place. So what does winning even mean in a situation like this? This little chart here really breaks it down for us. Did he prove the HOA broke its own rules? Yes, absolutely. Big success there. Did he get the dues increase thrown out? No, that was denied. Did he get his money back for filing the case? Yep, another success. So you see, it was a victory, but it was a victory of principle. So what are the big lessons here? What can we all learn from this? Well, first off, words matter. Every single word in a contract is there for a reason. Second, a technical violation is still a violation. You can't just ignore the rules because they seem small. And, maybe the biggest takeaway is that winning isn't always black and white. Sometimes just proving you're right and holding an organization to its own standards, well, that's the real prize. And that's really what I want to leave you with. Think about it. Mr. Stoltenberg put in the time, the energy, and his own money to fight this battle. He didn't get the financial result he wanted, but he proved he was right, and he forced the HOA to follow the letter of its own law. It really makes you think, when you're fighting for the rules, how do you measure what a true win really is?